This is an appeal in the matter of Rogerson and Erhard-Jensen Ontological Initiative Ltd.
My lord, my ladies, I represent the appellant, my learned friends, Mr. Edward Kemp, King's Counsel, Mr. Anurid Mather represent the respondent. The appellant wished to be here in person. However, unfortunately, his work prevents him from doing so. He's in the air at the moment. I'm joined by his close friend behind me, Fiona Hannon. I've spoken with my learned friends about timings today, and upon their suggestion and my agreement, I will speak between 10:30 to 12:30. I don't intend to use all of the time, but I'll see how I get on. The respondent will have 12:30 to 1 o'clock, and then 2 to 3:40, leaving me 20 minutes to reply, finishing at 4 p.m.
Okay.
But of course, I'm in the hands of your lordship in relation to that.
All right, well, that's something we can work to. We'll see how we go.
Thank you, my lord. The Appellant's Employment Tribunal claim set out in the court bundle of page 155 sets out the background to this case. In short, the appellant, Mr. Rogerson, worked under a contract with the respondent, working closely with a Mr. Werner Erhard, a purported self-help guru, along with approximately 13 others in Mr. Erhard's then central London home. These individuals, like Mr. Rogerson, were all under contract with different companies or organisations based outside of the United Kingdom, British Virgin Islands and Singapore in this particular case. There is, of course, an argument that they should have been classed as employees, but it might not take this particular appeal much further, but it might be something that your lord and my ladies consider in this case.
It doesn't matter for the purpose of a whistleblowing claim because a worker, with the extended definition of worker, can make a
Yes,
claim.
and it's accepted by the respondent.
So it's really irrelevant, isn't it?
The contract,
That might be an argument for some future occasion, but I don't think we want to get into that.
of course, my lord.
This.
Mr. Rogerson's contract with the respondent contained what we suggested is a broad breach of confidence provision, purported to prevent all discussion of Mr. Erhard, which would include any criminal acts to be committed, and which purported to continue to have effect forever. The contract also had a Singapore arbitration clause for any breaches of the contract, as well as a liquidated damages clause for $50,000 US. Mr. Rogerson's role included managing some of Mr. Erhard's staff, who were mostly recruited through the programs, the self-help programs which were conducted. We suggest it was no ordinary arrangement. Mr. Rogerson, in his evidence, described it as being a cult-like or even a cult, with Mr. Erhard being the leader. Mr. Rogerson saw Mr. Erhard being regularly physically violent and verbally abusive towards his staff members, including hitting, slapping, pushing, chasing after them, throwing food and other objects at them, pulling the hair of a staff member, strangulation of staff members, and pulling staff members by the ears. He was also told about physical abuse by staff members who he was managing, including throwing hot tea, choking, grabbing a female aide by the throat. His evidence didn't just come from himself, but from 7 other witnesses who produced signed witness statements. Mr. Rogerson also witnessed verbal abuse using humiliating language, including calling members of staff fucking bastards, piece of shit, cunt, bitch, and stating he would get bad with them.
I think the position is that all of these allegations are disputed and we know the nature of the disclosures which you say are protected disclosures. None of that, Mr. Pollock, is going to help us to decide the point that's in issue in this.
My lady, yes. I set out the background to the case for these reasons. The appellant would say it would go to whether there's proportionality in what we say is an extension of the immunity in this case. And we also say that is relevant because the respondent in their arguments, in their skeleton argument, do say that this is an attempt to relitigate the arbitration. And they make a strong point of that. In fact, the arbitration was decided in Mr. Rogerson's favour. This is no attempt to relitigate the arbitration. He was awarded costs, and the arbitration was found in his favour in relation to his disclosures about physical and verbal abuse. So that's the reason I mentioned the background to the case, my lady.
We haven't really been told until just this last moment what happened in the arbitration. It was hinted at that that was the outcome. We don't know very much about it. Was that an arbitration in which he participated?
Yes.
So it went to a hearing in Singapore?
It was a full hearing in Singapore.
With representation on both sides, or did he act in person?
I represented Mr. Rogerson in the arbitration.
And there is an award from the ICC Tribunal.
There is, yes.
Any reason why we shouldn't see that?
Not from the appellant's point of view. And I apologise that it's not in the core bundle, but we can make that available to you.
All right. Well, we'll see if Mr. Kemp has any objection to us seeing it in due course, but otherwise it does seem to be part of the story at any rate.
Yes.
Whether or not it has importance in the outcome of the review.
Mr. Rogerson's case is that after witnessing Mr. Erhard's behaviour to staff members, he raised concerns about that behaviour as affecting vulnerable people and how it might affect Mr. Erhard himself in relation to his reputation. And my lord, you will see that the disclosures were made to Chief of Staff, Ms. Monica Spitz, who's the partner of Mr. Erhard, and other senior members of staff and associates. After he left working for Mr. Erhard, he spoke out about Mr. Erhard's behaviour to a number of people. We say these are close associates of Mr. Erhard, even Mr. Erhard's brother, Harry Rosenberg, the CEO of Landmark Worldwide, which recruited staff for Mr. Erhard. Mr. Rogerson's case is that despite being aware of Mr. Erhard's behaviour, they didn't act on his submissions to them, but they responded through General Counsel Mr. Terry Giles, who also was Mr. Erhard's lawyer, initiated the Singapore arbitration against Mr. Rogerson.
And that's what you say is the detriment.
That's what we say the detriment, my lord.
I suppose it's less of a detriment than it might have been
Yes.
if he won in Singapore.
Then if he lost in Singapore.
Well, quite.
Yes.
And the detriment, I suppose, would be what, unrecovered costs?
In relation to facing an arbitration, this is an arbitration which went for over a year, as I remember it. The extent of the pressure and one's under when faced with such an arbitration as being someone without money. There's a liquidated damages clause of $50,000 which he was facing. Is part of the damages, if I may add that.
So pressure and distress, that sort of thing.
Pressure and distress. Also,
Sorry to interrupt, Mr. Perrin. I think the current case law suggests that for a detriment that doesn't amount to dismissal, well, it wouldn't matter because the claimant in this case is a worker, but the compensation that can be recovered can include compensation for injured feelings.
Yes. Thank you, my lady. And further to that, Mr. Rogerson in effect conducted the litigation himself. So there's his time costs, the pressure on him facing a Singapore arbitration against a top Singapore commercial law firm. He, in effect, with my assistance, of course, but he, in effect, was the litigator, having to respond to lengthy pleadings, as my lord, you will know, appear in arbitration cases. So that's part of the damages. At the time of filing his claim, of course, he didn't know of the result of the arbitration, and the focus was therefore solely on the bringing of it. It wasn't on anything decided by the arbitrator or any of the evidence given within that arbitration. The background to the appeal is this. It's set out at paragraph 2 of the skeleton argument. The Employment Tribunal claim was filed on 15th of November 2021. The arbitration in Singapore having been brought on the 21st of July of the first year. I should have to hand the date of the arbitral decision, but I can get that for you. But of course, it wasn't within that time period.
Yes.
At page 43 of the core bundle is a transcript of the Employment Appeals Tribunal ruling, which is being appealed. My lady, leave to appeal was granted by you on the 19th of March 2025, and that is at page 166 of the core bundle. In essence, we would say that this case goes to the heart of our whistleblowing protection, whereby a decision for the respondents in this appeal would allow companies to respond to whistleblowing by UK workers with overseas litigation, have no repercussions for doing so. In circumstances where we say they would be unlikely to be able to do the same thing within our jurisdiction.
Well, why has it got to do with anything, whether it's arbitration or litigation, and whether it's here or abroad? As a matter of principle, surely your position is, if it's a detriment for somebody to threaten me with legal action to enforce an obligation of confidence in the contract, which has the effect of stopping me making a protected disclosure or causes me harm as a result of having made a protected disclosure, then it must say fortiori be equally a detriment, if not more, if they carry out the threat and do it.
Yes.
Isn't that simply in a nutshell what your case is?
Yes, in effect, we say that the initiation is not caught by the judicial.
Forget judicial immunity.
Yes.
Just stand back and look at it as a matter of principle. Parliament has said if you make a protected disclosure, you're protected. And that surely that's the be-all and end-all of it. We've got statutory protection for whistleblowers. If somebody threatens litigation or arbitration against someone for being a whistleblower, that's a detriment. If it's a detriment to make a threat, then it seems to me, as a matter of basic common sense, that bringing the action must also be a detriment.
Yes.
And why should you be immune from doing that if Parliament says you should be protected?
Yes. Well, my lady, I don't disagree with your point. The case law in relation to parliamentary intention of the Employment Rights Act. My learned friends argue that the case of Heath covered parliamentary intention. But I will come to that. But what we say in relation to parliamentary intention is that it couldn't have been the intention of Parliament in passing this law to be saying you can have the rights as a whistleblower not to be subject to detriments, but you can be taken to court for whistleblowing, and that can't be a detriment. So that's what we submit in relation to that.
And that's what we'd need to find, isn't it? Because if as a matter of obvious use of language, it is a detriment to be sued for breach of confidence, making a protected disclosure, then we would need to find something, or the respondents would need to find something which says that that particular detriment doesn't count for the purpose of the legislation.
Yes.
And you certainly can't find that in the legislation,
No.
so it's got to be found somewhere else. So the question is, where do respondents, or where does the judge say that that is to be found?
Yes, and I understand my learned friends will argue that there needed to be within the statute specific provisions which would have excluded the bringing of a case as a detriment. That's how I understand the case as they put it. But we say more generally, perhaps Parliament would have sat there and thought, well, the giving of evidence can't be a detriment because we know about that as a core immunity within a case, if that's what you find. But they wouldn't.
Well,
Parliament
immunity from what? You're immune from defamation, for example, for
Yes.
things you say in court. But you're not immune in other respects. You're not immune from perjury proceedings, for example.
Yes.
So it's not very helpful. It's not say you're not being helpful, but it's not very helpful in general just to speak about immunity without saying, well, immunity from what?
Yes.
The question really for us is there an immunity from suit in this situation?
Yes.
If there is to be an immunity from suit in this situation, I would expect it to have been specifically said so by Parliament in some legislation somewhere. Because if you look at the whistleblowing statute, one of the things it does say, as my lady has pointed out, is that if there is a particular provision in a contract which says that you shall not whistleblow, it's null and void.
Yes.
And so any action to try and enforce that contract would be wrong.
Yes. And we would of course submit in those circumstances if it's wrong here, it's wrong overseas.
Yes.
And that's a point.
The fact that it's overseas is neither here nor there. The fact that it's a consensual process that you've agreed to resolve disputes as an alternative to going to court is neither here nor there. The question, the principle, is whether or not any type of action to enforce an obligation not to whistleblow is something that Parliament says you can do with impunity.
Yes, and respectfully, Employment Judge Fowl made that point in his decision.
Anyway, just to say, I mean, these, as you will gather, these interventions are really helpful to you, and perhaps more for Mr. Kemp to deal with in due
Yes.
course. But we'll shut up now and let you make your submissions. But it's maybe helpful to both sets of counsel to know how we see the issue at the moment. But obviously, the arguments.
Thank you, my lord. The first argument, the first round of appeal is that the Employment Appeals Tribunal fundamentally misunderstood the legal test to be applied for establishing the appellant's case. I'll address this ground first, and it's set out paragraph 8 to 11 of the skeleton argument. And we submit that the essence of the claim is the bringing or initiation of the arbitration as a detriment under section 47B. The Honourable Mrs. Justice Heather Williams of the Employment Appeals Tribunal said on the application to her for permission to appeal, which is at page 88 of the full bundle, this: as regard the new point raised at 3, whilst the burden is on the employer to prove the reason for the detrimental treatment, as confirmed at the appeal hearing, the relevant detriment is pleaded or relied upon as the appellant commenced groundless arbitration proceedings against respondents in Singapore. It's respectfully submitted that the above characterisation ignored the legal tests in relation to what is needed to establish success in the claim. And by doing so, leaving aside the ladyship's point about parliamentary intention, we say she fell into error in categorising this as a claim which could impinge, leaving aside such an intention, upon the core immunity because of her decision. The relevant legal questions for the appellant to establish his claim at trial are set out, apologies my lady, at paragraph 12, 1, 2, 3, and there must be a link, of course, between the detriment and the act or omission, but as explained, the test to be applied means that there must be material influence, but once raised, it's for the respondent to prove that it wasn't the cause. It's referred to as the reason why test by Lord Justice Elias. There's no requirement for any malicious motivation inflicting a detriment, which is set out in Croydon Health Services VHS Trust and Beat by Lord Justice Underhill, as well as can be seen in paragraph 9.80 in whistleblowing law and practice.
I don't think we've got the request for arbitration, but if it says something like the disclosure you made, as you say, is the protected disclosure, is a breach of an obligation of confidence,
Yes.
and that would seem quite likely to satisfy the necessary link test.
Yes, my lord. In relation to that, the response to the Employment Tribunal claim, the first response from the respondent seemed to agree that link. The second response, the updated response, seems to put that link in issue, and the respondent raises some points in relation to that, which I won't address now, but we say that at the very least, when Mr. Rogerson comes to give evidence and says, I made these disclosures, 6 months later I got an email from the Singapore solicitors saying, please find and attach a request for arbitration, puts the burden on the respondent. And the respondent, it may, if they want, call evidence to say, no, that's not why we brought the arbitration, but it would be very difficult for them in the circumstances.
So how does that work for us? So far as we're concerned, in this appeal, there either is or may be an issue before the Employment Tribunal about whether that link is established.
Of course,
but
yes.
We proceed on the basis that
It can be established. Yeah. We submit that's not a point for you today.
Okay.
But in relation to that, what we say, we make this quite clear, is that proof does not rely on anything that was said within the arbitration. It doesn't go to anything that was said. We raise it, we can prove it, as I've said just now. That might not be the way we prove it, but on the basic level. And then it's for the respondents to say that's not why we brought the arbitration, if they so wish to do so. So we say that if it's argued to you that this impinges on witness evidence before the arbitration, we say that's simply not right. At paragraph 14, I've set out the statutory provision at section 48.2, that's for the employer to show the ground on which the act or delivered third act was done. And in the absence of satisfactory explanation from the employer which discharges that burden, tribunals may, but are not required to, draw an adverse inference. And that's the case of the Chief Constable of Greater Manchester Police in Aston, which is within the bundle. So in short, in relation to the what's there to be proven, we say there's nothing in what the appellant needs to prove which will call into account witness evidence, and therefore that should not be a reason for blocking the claim, and in any event that's a decision for the Employment Tribunal to
I'm
consider.
just trying to get my head around what the judge was saying. A moment. She seems to be taking a pleading point, because if you look at paragraph 17 of your very helpful skeleton, it says that the judge said she didn't have to decide whether the immunity would apply if the pleaded detriment was simply that costly, straight, inconvenient arbitrations were initiated against the claimant. You say, well, that would be enough to suffer a detriment. She seems to have latched on the word groundless in the pleading.
Yes, and our submission is that, respectfully, she misunderstood the appellant's case, in that she imported that need for the claimant to prove bad faith or malice.
Why is the word groundless in the pleading?
Well, my lady, I may have said, I don't think I bound myself that we had to prove it. I may have said or described it as groundless within the hearing. I don't quite remember. But in any event, when we look at His Honour Judge Fowles' understanding of the case, which I've set out, it's quite clear that that does not have to be proven. He identifies
I
it.
suppose that bringing groundless proceedings is even worse than bringing grounded proceedings.
Yes.
But perhaps more seriously, if disclosure was a protected disclosure, and if the claim was that the bringing of protected, making of a protected disclosure was a breach of confidence, then the proceedings would be groundless, because the statute says that any confidentiality obligation is void.
Yes.
So you would, it all comes back, may do, to whether this is a protected disclosure.
Yes, my lord.
In any event, as you were hinting, the way that the employment judge approached it, see paragraph 31 of the employment judgment, the employment judge refers to the suggestion that the motives for bringing the arbitration were improper. The employment judge will not set out all of his submissions, since it's not necessary, in my view, for the claimant to demonstrate any particular motive of malice or misconduct. So the Employment Tribunal approached it on the basis that the motive was irrelevant, that all you needed to show was the detriment, i.e. the initiation of the arbitration proceedings.
Yes, my lady. The employment judge, we say, understood the claim and what needed to be proven.
Yeah.
And respectfully, at the Employment Appeals Tribunal, this was not understood. In the Employment Tribunal, we had a number of days on this issue. I don't know if I remember exactly, but I think there were other issues discussed, but we spent at least a couple of days on it. So there was more time in relation to this to consider it. And we simply submit that that the Employment Appeals judge states she doesn't have to decide the question, and therefore the question is for my lord and my ladyship to decide. And she quite clearly sets that out in our application to her for permission to appeal.
Well, the question is, was the Employment Tribunal wrong to take the approach which it took in paragraph 31?
My lady, yes. And if we turn, I don't seek to turn away from the pleadings. If we turn to the pleadings, we can see what's set out. If I may just have one moment. It's page 172. Oh no, sorry, it's 100. I had it open. It's 160 of the pleadings. And what we say is that the Judge Fowler correctly interpreted this, and the main thrust of this detriment is the commencement of arbitration proceedings, which is stated at the top, the first respondent commenced arbitration proceedings against the claimant in the International Chamber of Commerce in Singapore. Mr. Rogerson, acting in person, then goes on to describe effects of it. It is extremely costly. This was at a point, of course, before he knew that he would be awarded his costs by the arbitrator. And then he goes on to say, the arbitration claim alleges the claimant has breached his confidentiality and consulting agreement by making communications of allegations. My lord, this, we say, is also sets out the stall in relation to what his case is, and the burden, we say, in relation to that falls on the respondent.
What was the amount of the deposit which the ICC required to be put up?
In relation to the deposit, as I remember, Mr. Rogerson wished at that court to be able to make a counterclaim, but he didn't have any money. He's without funds, so he didn't have to submit a deposit. The respondents did.
Well, usually they ask both parties to supply 50% of the amount, and the respondent doesn't, so the claimant ends up having to fund all of it once its case to be heard. That's how it usually works,
Yes.
at least in my experience.
So the arbitration was funded by the respondent.
Yes, and what was the amount of the deposit the ICC asked for?
I can't remember exactly, but we have that. We'll find that for you. So my lord, my point, when this is considered, we say the top part where it said commenced arbitration proceedings against claimant in the International Chamber of Commerce doesn't import any malice, sets out clearly what is being claimed as a detriment, and then what comes.
No, sorry to interrupt you, but the word groundless doesn't appear in your pleading.
No, my lady, it doesn't.
So I don't know where the judge picked that up from, unless it was something, as you say, that maybe you described it as groundless orally.
I may have.
Yes.
And
But if you're looking at the pleading, simply it's the bringing of arbitrary proceedings, claiming all this relief, accusing in the arbitration claim, accusing the claimant of various misfeasances.
yes,
Then it appears you made a submission to the Employment Tribunal that the motives for bringing the arbitration were improper. That's a submission. I've got a reference to the pleadings. And then the employment judge says, well, I don't need to bother with that because you don't need to establish any motive.
my lady, yes. And in relation to the pleadings, we say the first part pleads quite simply the initiation of arbitration proceedings. What comes underneath is relief, but this was drafted at the time, of course, before the arbitration decision had been made. We say there'd be nothing wrong with the Employment Tribunal allowing amendment, the respondent already having been allowed to amend their grounds of resistance. And what comes underneath from additionally, the false claims, it does raise false claims being raised in arbitration proceedings, but what's stated below in the two bullet points, 24th of February 2021 and 4th of March 2021. The first is that Mr. Super responds to the claimant's request for a call as follows: no thank you to your offer. Your real intentions are well known. I can consider your actions reprehensible. Dr. DiMaggio stating, I got your message. I don't agree with what you said in your message. I've been told that your motives behind what you were saying are not as you say. Given all that, I'm declining your request to talk. My point in relation to that, of course, is that's pre-arbitration. So the nub even of the second part appears to be things which have been said outside the arbitration, things have been done outside the arbitration. But as your ladyship identified with granting permission, this is a claimant acting in person. We say he's done a fairly good job of it in setting out what he's proving there, what he sets out to prove as the detriment. In those circumstances, the learned appeal judge wrongfully identified what the issues in the case are. In relation to the second round, I make these submissions bearing in mind what my lady has said in relation to the parliamentary intention, whether it was barring these whistleblowing cases of detriments based on litigation brought, whether in this jurisdiction or another, especially given the intentions in relation to section 43J that has been noted. But we say that there's been, even if judicial proceedings immunity was to apply contrary to what we say is the statutory intention, that there has been a move to limit judicial proceedings immunity in many ways, from what originally was broader to what we say now is quite restricted. And the arguments in relation to this are set out in paragraphs 20 to 50 of the Skeleton argument. We break down the law into a number of areas of focus, including the scope of judicial proceedings immunity, the rationale behind the core immunity, and any extensions to it, and distinctions that the court, we say, has drawn between acts initiating legal action and evidence given within a particular hearing. At paragraph 28 and 29 of the Skeleton argument, we say that the current focus of judicial proceedings immunity is on that first category, as identified by Lord Justice Devlin, Lincoln and Daniels, 1962 Queen's Bench reports at page 237. Matters done before a court, everything that is said in the course of proceedings by judges, parties, counsel and witnesses, including the contents of documents put in as evidence. And we say there's been a judicial move towards the focus being on this first category, the witness evidence provision, as being the core immunity. And this can be seen as we pass through the case law. The case of Roy and Pryor, I will start with, which is at the authorities bundle at page 102. The relevant paragraphs are in the Skeleton argument, paragraph 30 and 31.
Do you want us to look at the case or stick to the skeleton?
My lord, I will ask you to turn to the case.
Yeah, that's fine.
The facts of the case are at page 102. In effect, the case was about a criminal case whereby a medical witness was required to give evidence. In that case, an application for a summons was made and granted. The solicitor, it seems, forgot to serve that summons and then instructed counsel in the trial to make an application for a warrant of arrest. The medical professional was arrested at the very early hours of the morning and was brought in custody to court and brought a claim in relation to that. Part of the arguments in the case were that because part of the claim rested on what the barrister had said to the court about the expert not being available or not being willing happened within the court, the claim was barred in relation to judicial proceedings immunity. At page 105, we can see the detriments which were pleaded in that case. The claim, sorry, it sets out what was pleaded. And in relation to the case, we can see at paragraph 6, at the trial of Mr. Advani, he was the defendant in the criminal case, I understand, the defendant falsely alleged that he had taken proper steps to serve the said witness summons on the plaintiff, accuse a plaintiff maliciously without reasonable or probable cause, or having willfully evaded the service of the witness summons. And he instructed his advised counsel to apply to the judge for the issue of bench warrant for the arrest of the plaintiff. At page 106 of paragraph D, questions which are set out in relation to the House of Lords' answer. And number 2 is relevant. If the plaintiff is debarred from proceeding such an action, because one of the steps taken by the defendant to secure his arrest consisted of giving false evidence on oath. You can see at page 108, it's submitted by the respondents in the case that the general immunity of witnesses extends to these circumstances. And that was one of the points which went to appeal. At page 107 of paragraph F, that was one of the points to be grappled with by their lordships. We suggest that the court on this occasion was grappling with the limits of the judicial proceedings immunity rule, and whether, because there was evidence as part of the claim given, this would bar the claim. At page 109, paragraphs A to H, we suggest what it states is this: the judgments of the Court of Appeal were based upon the ground that the arrest of the plaintiff was caused by the evidence which the defendant gave in the witness box, and that the action was not maintainable, and in the circumstance of this case, what the plaintiff alleges is the defendant acted both maliciously and without reasonable cause, procured and brought about his arrest. The plaintiff is not suing the defendant honour and respect for the evidence which the defendant gave in court. The plaintiff is suing the defendant because he alleges that the defendant procured his arrest by means of judicial process, which the defendant instituted both maliciously and without reasonable cause. We say that goes to the point about instituting a process not being covered. And this case, of course, is a particular type of case. We say this is part of the court's acknowledgement or movement towards focusing on whether a claim is based on evidence given or not.
Well, isn't it more? I mean, just having a quick look at the reasoning of Lord Knowledgeable, yes, isn't his point that you've got to look at the nature of the claim that's being brought? If you're bringing a claim for malicious arrest or malicious prosecution, that's the nature of the claim, and it's wrong that that kind of a claim should be defeated by relying on supposed immunity for things said in court, because essentially you're attacking an abuse of the process of the court. See what he says at paragraph G. So the focus should be not some, I think Justice Mayles was suggesting, not some abstract immunity, but what is it immunity from? That involves you asking a question: what is the nature of the claim that you are bringing? And the point here is that the claim for malicious prosecution shouldn't be defeated by relying on immunity that apparently cloaks things that you've said in court. If in fact what's going on is an abuse of process.
The same could be said of perjury, the same could be said of any other abuse of process.
My lady, yes.
And by extension, it might be said it's an abuse of the process of the court or an abuse of arbitral powers to use a process to prevent whistleblowing or to gag whistleblowing.
Yes, especially when to do so under English law would be prevented from happening. And that's really the point that I wish to pull from this case. We're not saying, of course, that it's factually on all fours with this case, but we do say that it's relevant as to what the courts are looking for when they consider the application of the immunity, if the immunity indeed applies.
It seems to have been quite important in this case that there was an allegation of malice, which, if we transpose that to our case, I suggest that if you had said groundless in your pleadings, which it looks as if you didn't, if you had, then that would have been appropriate.
It may have been, and
Well, maybe that's to do with the fact that the tort that's being invoked is malicious prosecution,
Yes,
so
right.
malice is an ingredient of the tort.
yes,
And of the employment judge's reasoning, malice is not an ingredient, but a necessary ingredient of your claim.
yes,
All
yes.
you need to do is to show the detriment.
My lady, yes. And at page 111, the Lord Morris states this. He really goes, we say, in relation to initiation, this is the point I wish to draw out of it. An affidavit in support of a petition for adjudication had been necessary. He's quoting, I'm sorry, from the case of Johnson and Emerson. And we say really that the initiation is seen as something which is separate from what somebody going after a witness, going after what a witness has said in court. And he makes this point right down the bottom of the page, paragraph H. Different consideration would apply for claimant one for damages in respect of evidence given by a witness. The present claim is not such a claim. The gist and essence of the claim is the process was instituted as a result of which the court was induced to order the arrest of the plaintiff without reasonable cause on the next page, and that the giving of evidence was merely a step in the bringing about the alleged abuse of process. He goes on in paragraph D, the reasons why immunity is traditionally, and for this purpose I accept the tradition conferred upon witnesses in respect of evidence in court, and are in order that they may give their evidence fearlessly and to avoid a multiplicity of actions in which the value or truth of their evidence would be tried over again. We say both these reasons don't apply in the instant case, and we're not seeking to relitigate anything which was said or done before the arbitration, of course, with Mr. Rogerson being quite content with the decision of the arbitration. He does set out a general theme the courts have identified at paragraph F. Immunity is conferred by the law in respect of legal proceedings need always be checked against a broad view of the public interest. We say in this case, there is no public interest in allowing a overseas organisation to have UK workers and to bring in response or as a result of a disclosure to bring litigation against them where they would not be able to do so in English law.
Well, what's quite interesting is if you read on in the report, it says between F and G, immunities conferred by the law in respect of legal proceedings need always be checked against a broad view of the public interest. And then he says, there's no public interest for protecting absolutely what the solicitor said in court in the context of that case.
Yes.
So it's very similar to, even if the proceedings in that case have been grounded upon evidence given in court, that wouldn't be nothing but Wilkins's view, because you look at the wider justification for the immunity. And so
Yes.
that's what we're concerned with here.
My lady, yes. And that theme about the restriction of the immunity because it allows a wrong without a remedy is repeated time and time again throughout the case law.
Well, you say that Parliament has told us what the public interest is in whistleblowing cases,
Yes.
namely that there should be no detriments, and that if there is, you can bring a claim in the Employment Tribunal.
My lord, yes. And the next case I wish to turn to is the case of Darker. And In that case, Lord Wilberforce suggests a dynamic approach to immunity with the law evolving to meet the changing needs of society. And this case is set out at page 244. The facts of the case are set out in head note. There was convictions in relation to conspiracy to fraud travellers' checks and import cannabis, and the judge at trial had ruled that the police had been significantly at fault in respect to disclosure, directed the charge be permanently stayed on the grounds of abuse of process. The plaintiffs brought an action against the defendant, chief constable, claiming damages for conspiracy to injure and misfeasance in public office, alleging that police officers fabricated evidence against them. The defendant applied for the statement of claim to be struck out, claiming that the acts alleged were covered by an absolute privilege or immunity. The judge struck out the statement of claim and dismissed the plaintiff's action. Court of Appeal dismissed the plaintiff's appeal. And it was held that the public policy required in principle that those who suffered wrong should have a right to remedy, that although the absolute immunity from action given in the interest of the administration of justice or party or witness, including police witnesses, in respect of what he said or did in court, extended to statements made for the purpose of court proceedings and to prevent him being sued for conspiracy to give false evidence. Public policy did not require it to be extended to things done by the police during the investigative process, which would not fairly be said to be part of their participation in judicial processes as witnesses. The immunity did not extend to cover fabrication of false evidence, and the statement of claim should not have been struck out. In relation to this case, we say this is more in relation to a movement of the courts to limit the immunity.
You might say to prevent it being extended to things that the police do during the course of their investigation, which isn't something that you could say it's an effort to prevent the immunity from being extended too far.
My lady, yes. Lord Hope sets out the core of the immunity, we say, at page 254 of the bundle. And talks about in relation to police officers, when a police officer gives evidence, he has the benefit of an absolute immunity. This immunity is regarded as necessary in the interest of the administration of justice. It is granted him as a matter of public policy. Is shared by all witnesses in regard to the evidence which they give when they're in the witness box. It extends to anything said or done by them in the ordinary course of any proceeding in a court of justice. The same immunity is given to the parties, the advocates, jurors, and the judge. They are all immune from any action made or against them on the grounds of things said or done by them in the ordinary course of proceedings or said or done falsely and maliciously without probable cause. In this case, he goes on, no challenge is made. What may conveniently be described as a core immunity. It is not suggested that police officers who participate in proceedings as witnesses should no longer have the benefit of it in regards to things said or done by them whilst they're actually in the witness box. The question that has been raised relates to the further extent of the immunity. Where are the boundaries to be drawn? It arises because there is another factor that must be balanced against the public interest in matters related to the administration of justice. It is the principle that a wrong ought not to be without remedy. Immunity is a derogation from a person's right of access to the courts, which requires to be justified. And he goes on, paragraph D, if their claims related only to things said or done by the police officers while they're in the witness box, they would be excluded by the core immunity. But the police officers to whose conduct the claims relate did not enter the witness box. Interestingly, we would submit at the bottom of the paragraph H. The public policy underlying immunity are essentially twofold. protect persons acting bona fide who under a different rule would be liable not perhaps to verdicts and judgments against them, but to the vexation of defending actions. Second, as Lord Wilberforce said, to avoid a multiplicity of actions in which the value or truth of their evidence will be tried over again. The second of these two policy reasons relates only to the core immunity, as it's limited in its application to things said or done in court. And so we say the multiplicity of actions rationale applies to things said or done in court. And over the page, Lord Wilberforce made this clear that this immunity she was considering was that of witnesses in respect of evidence given in court. The plaintiff's allegation relates to things done outside the courtroom, so it's the first policy reason only which is relevant to this case. And we say in relation to this that this is the bringing of the arbitration. It's not something which happened before a tribunal, within a tribunal. It was an action which is outside that.
I see that there are 5 separate opinions in this case. Lord Mackay agreed with Lord Hutton. Do the other members of the appellate committee, is their reasoning consistent with the passages that you've read us?
Lord Mackay does agree, suggests that the focus is on evidence to be given. Lord Cook's statement of principle is at page 262, paragraph D and E. We say this is relevant. Absolute immunity is in principle inconsistent with the rule of law, but in a few strictly limited categories of cases, it has been granted for practical reasons. It is granted grudgingly. The standard formulation for the test for inclusion of a case in any of the categories are being set out by Sir Thaddeus McCarthy opposition. Protection, and that's in the courts of New Zealand, I believe. The protection should not be given any wider application than is absolutely necessary in the interest of the administration of justice. Many other authorities contain language to similar effect. Lord Hutton is at page 277.
That's the lead judgment, isn't it?
Yes. Yes, my lady. In short, what we respectfully submit, that although the case is not on all fours with this incident case, that what the lordships are identifying is the restriction of the immunity where it applies because it removes the right to a remedy, and that the focus of the core immunity we would submit is that witness immunity before the court. My learned friends rely on the case of Heath and the Commissioner of Police, 2004, New Wales Criminal Appeal, Civil Reports at page 943. This is at page 282 of the bundle. In short, what happened in this case is that there was a complaint about a sexual assault by a police officer. The commissioner appointed an all-male disciplinary board, and the complaint really boiled down to 3 complaints by the claimant in that case. The first was that they were all male. The second was that a female officer who'd come to accompany her had to plead to be allowed to remain in the room. And the third, and possibly the real nub or the mainstay of the claim, was that during cross-examination by the commissioner, by the barrister representing the police officer who was being judged in relation to disciplinary proceedings for sexually assaulting her, she was asked to demonstrate how the sexual assault took place by being asked to cut or squeeze her breast, and that was the complaint there. In that case, the Court of Appeals said that what this case concerned was things before that board, before that disciplinary board, and we suggest that case really doesn't go to what we're discussing in this case, which is the initiation, as my lord, you can see. At page 291 of the bundle, Lord Justice Old sets out that the immunity rule doesn't only attach to defamatory statements, and he goes on to make a comment that attaches to anything said or done by anyone in the course of the judicial proceedings, whatever the nature of the claim made, in respect of such behaviour or statement, except for suits for malicious prosecution and prosecution for perjury. We state that that statement of law has been overtaken by later decisions, which state two things: that the anything said or done is too broad a proposition, and that malicious prosecution, prosecution for perjury, and proceedings for contempt of court are not a identified single category whereby the immunity does not apply. The consideration in this case of the Commissioner's selection of an all-male board is interesting, we say, because there was a disagreement between the judges, their lordships in this case, and that can be seen at page 361. Apologies, I've given you the wrong reference.
I'm not sure to what extent this case really is in point, because the issue, the two issues, one was whether the immunity for things that were said and done in court only applied in defamation cases, and this court said it doesn't, it's not just defamation cases. And then the question was whether or not it applied to proceedings in tribunals as well as to court proceedings.
Yes,
And this court said it applies to tribunal proceedings.
yes, my lady.
So those were the two issues that the court had to decide. But I can't see anything in this case that has any bearing on the question of whether the initiation of process is subject to immunity.
No, my lady, and that's a point I wish to make. And Lord Justice Neuberger at page 315, we say his decision is interesting and pushes the other way against initiation. He sets out the allegations, intimidation because of the membership of his disciplinary board, as being separate to the union representative having to plead to be present and the incident description of the sexual assault, and says that he separates and says that the choosing of that all-male police disciplinary board could be considered by the court, was not covered by the detriment. Immunity, I'm sorry.
But why are we interested in his judgment because he was dissenting? He dissented.
Well, in relation to the dissent, we say that when one comes to consider what Lord Justice Old says about it, he's not, we say, he's not objecting to what Lord Justice Neuberger is saying in principle. at page 361. I'm sorry. He says this. I have to confess that the consideration, that's Abel Newberger's consideration, never occurred to me when preparing the draft of my judgment. Largely because, as I said in paragraph 11, I took the main thrust of Miss Heath's complaint to be at its broadest, whether the rule of absolute immunity from suit that attached to judicial quasi-judicial proceedings excludes complaints about unlawful discrimination conduct in the course of such proceedings. So he's approached at looking at the facts of the case and said what this case is really about is what happened within the proceedings. She's complaining about an all-male panel being put in place, but that only affected how they treated her within the proceedings. So respectfully, what we say in relation to that is that they've made a different factual determination. But what he's not saying is that the actions outside of the proceedings should have obtained some kind of immunity that the commissioner selection should have. He's saying his interpretation of the case is simply that it's what it really is about is what happened in the proceedings in that case. In our case, we say what it's really about is the initiation, and we don't, of course, challenge anything which is said. I move on to the case of Lake. The case of Lake is at page 321 in the bundle. In this case, there was a police officer who attended a crash scene. One of his fellow constables collected bones from one of the deceased. He ended up whistleblowing about it, and he was brought to a tribunal in relation to that. And it was held at appeal that he was not seeking to challenge the customary immunity from suit enjoyed by those engaged in proceedings in judicial proceedings. He was saying that the commissioner made the wrong decision based on what the board had decided, and which is one point which can be pulled from it. However, there's another point to this case, because there were two complaints in relation to the case. One of the complaints was that the initiation of the board was a detriment. So taking him to the board because of his whistleblowing was a detriment in the case. And we submit that it's relevant for that reason as well. At paragraph 27, page 327, sorry, we can see at paragraph 24, the point that I was seeking to make is that the complaint was on two reasons. The disciplinary proceedings were taken against him because of his disclosure, and then he was dismissed because of his disclosure under section 103. It was also submitted that the service on the claimant of the conduct charge itself amounts to a detriment within the meaning of section 47B. Lord Justice Peel goes on to talk about the customary immunity in paragraph 27. The customary immunity which judges, advocates and witnesses enjoy as confirmed in Heath is not challenged in the appeal. So in that sense, impeachment does not take place. At paragraph 30, we say this is relevant. And of course, one of the points in the case was that the Employment Tribunal could take a different position than the disciplinary board, which is one point which can be taken from it, but not one we say which is relevant to this case. it says here, if the paragraph above, that is from the appeal, which says it's however directed that the proceedings before the police disciplinary board, the decision of the board cannot form the basis of the dismissal claim, those proceedings, that decision being immune from suit. And then the main point, if that paragraph does mean that the Employment Tribunal could not reach a different decision from that reached by the board, or could not consider evidence contrary to that decision was wrong. Of course, if an attempt were made to call as a witness the chairman of the panel constituting the board to justify or to explain his decisions, or to impugn remarks he made in the course of the proceedings, the chairman would be protected by the immunity for his actions, which has long been established. This is not a case in which the manner in which the board has conducted proceedings has been challenged as biased or unfair, or in itself giving rise to a claim. We say that's relevant to the instant case. And the bottom of the paragraph, the claimant must show, in accordance with section 103A, that the making of protected disclosure was at least the principal reason for the detriment and the dismissal. So the detriment in this case is bringing the disciplinary case against the claimant, as well as his dismissal, and the dismissal, of course, for making the protected disclosures.
But it appears to have been accepted, see paragraph 25 of the Judicial Justice Pill, that the detriment claim relating to the bringing of charges could proceed to a full hearing.
Yes, it does seem to be accepted by the court. But what we'd say is that
accepted by the other side of the claim, accepted by the chief constable of the other respondent.
yes,
So that wasn't an issue, wasn't the appeal?
my lady, in relation to that, I'd say that Lord Justice Pills considered the case and considered there's nothing wrong with that in those paragraphs that I've referred to. But in relation to the understanding of that decision, at page 998 of the authorities bundle, we have the whistleblowing textbook in relation to their understanding of it. And it states here, the basis for this conclusion was Mr. Lake's claim did not involve impugning the proceedings before the disciplinary panel for any assertion that the decision itself gave rise to a claim. Part of Mr. Lake's claim that disciplinary charges had been laid because he made protected disclosures. It was accepted that such a claim could be brought. And we say that what can be brought out of this case, and supported by later authorities, is the initiation of a case before a tribunal or court is not something which is taught by that core community.
But that goes back to the point I just made to you. It was accepted by the respondent in that case that the claimant could rely on the bringing of proceedings as a detriment. So
Yes.
there wasn't an issue about it. So we don't have a binding decision to that effect. All we have is one party's litigation accepting that that was so.
My respectful submissions in relation to that is that it's been considered by Lord Justice Hill, who looks at the customary immunity, and he notes what he says in paragraph 30, respectfully we submit, is that he says what would be caught by the core immunity, but is not caught in that instance, is not caught in the case which is before for consideration.
I think you can say that Lord Justice Pill has independently expressed the view that the Employment Tribunal has jurisdiction and make up its own mind as to whether or not a section 103 case, 103A case would be established. In other words, to determine the question of whether there was a protected disclosure or not. And that was the principal reason for the detriment and the dismissal, but he's not actually focusing on whether the bringing of the disciplinary action is in itself a detriment because, as my lady says, that was conceded.
All effectively he's saying is that it was open to the claimant in that case to challenge the reasoning of his disciplinary rule in his section 103A unfair dismissal claim in the ET. So in other words, the ET wasn't bound by the findings of the police disciplinary rule.
My lady, yes, we can see that that's the nub of the case, but we do also say that it's relevant in relation to what the claim was, and that claim was allowed to go forward. I make no further points in relation to that.
So looking at our case, if the arbitrators in Singapore had found against your client,
yes,
then that wouldn't prevent him from litigating the issue whether there was a protected disclosure before the Employment Tribunal.
no, it wouldn't. No, your lordship's quite right. But even further to that, the bringing of the arbitration, we say is the nub of it.
Well, we've got
You've got that point, yes. Thank you, my lord. The next case I wish to turn to is the case of Singh and Reading Borough Council, 2013, England, Wales. Appeal reports at page 909. And at page 39 of skeleton argument, I set out that this was a case whereby a head teacher brought a case against a local authority for placing pressure on a witness to produce a statement containing false evidence. In this case, it was stated that the appeal involved the clash of two principles: the principle that a wrong should not be without a remedy, the principle that those involved in the process must be immune from civil suit. What they do say in the course of the litigation. At Lord Justice Lewison conducts a review of the case law, and I've set that out at paragraph 40 of the skeleton argument. And in regards to paragraph 40D, if I may read from paragraph 38. Mr. Allen also relied on general statements made by highly distinguished judges. I've already referred to Lord Hoffman's warning that it is illegitimate and dangerous to generalise the scope of the judicial proceeding immunity rule. And then he says, I've quoted part of the judgment in Dawkins and Lord Rockerby. Mr. Allen relied on the immediately following passage in which Justice Kelly said, no action lies against parties or witnesses of anything said or done, although falsely and maliciously, without any reasonable or probable cause, in the ordinary course of any proceedings in a court of justice. And then Lord Justice Lewison says, this statement must be read in context, and B, the cases to which Kelly referred in making that observation were cases in which the foundation of the cause of action was evidence itself. The context was the demonstration in the concluding proposition that upon all these authorities, it may now be taken to be settled law that no action lies against the witness upon evidence given before any court or tribunal constituted according to law. That is a narrow conclusion and the observation on which Mr. Allen relies. We suggest that when the case law and the statements in relation to everything said and done are looked at, that this is relevant as to the extent of things said and done. The focus really is on things said and done before any court or tribunal. And we'd say the request for arbitration is not such that would be considered within that category. At page 394, paragraph page 393, he gives, Lord Justice Lewison gives some examples of things which would not be caught. He gives an example of paragraph 63 of the case of England and Chenwes, a litigant whose confidential documents being obtained for the purpose of litigation is entitled to an injunction requiring their return. And this case, in my judgment, is also inconsistent with the broad proposition that no civil liability relies for anything said or done in the course of litigation. He says other examples come to mind that are inconsistent with broad proposition. A party alleging that a judgment was obtained by bribery. He gives an example in paragraph 64. At paragraph 65, we say is relevant. If a party begins court proceedings in breach of an arbitration agreement or an exclusive jurisdiction clause, the court may intervene by the grant of a stay for an anti-suit injunction. There is no reason in principle to deny the remedy of damages for breach of contract. The initiation serves the process falls squarely within the second of Lord Justice Devlin's three categories. We say that this is important for a number of reasons. That although initiating service was within Lord Devlin's second category, it does not attract immunity. We say this goes to the point I made, that the focus now on immunity is that upon the first category, things that are done before the court. And we say we've seen no case which goes against this, prevents an action based upon initiation in service even domestically, let alone internationally, and shows, we say, the current understanding of where the absolute immunity applies.
That's an interesting submission recorded by Ms. Williams, who represented, I think, the claimant in that case.
She did, yes.
Paragraph 67.
Yes, and we would, I hadn't adopted that, but we would adopt that and say that the bringing of the arbitration, just simply because evidence is given a later period, does not, as retrospectively immunise the action of bringing it. And we say further points in relation to that paragraph, paragraph 65, we say, if using the courts in breach of an arbitral agreement can be a cause of action attracting damages for breach of contract, why cannot initiating an arbitration in breach of English statute also attract damages? We say there's no reason in principle for this.
What that shows is that there is no blanket rule
Yes.
that initiating proceedings cannot be a civil wrong.
Yes.
Therefore, you've got to look specifically at the nature of the proceedings and the circumstances of the case to see whether there is a justification for the immunity.
Yes, my lord, and we'd say that takes it outside of the absolute immunity, which the respondent argues that this case falls within.
Yes, whether you have to do what the rule says, which is check whether the immunity claimed is in accordance with public interest.
Yes, yes, my lord. And respectfully, in this case, we say it's not. We'd say in relation to arguments about comity, if the English courts can be used to protect access to arbitration, they should comity should allow them to be used to protect workers when arbitration is initiated in breach of English statute.
Well, nobody's stopping resort to arbitration. The issue is, should there be any consequences for a claim for whistleblowing detriment, which is a different issue.
My lady, yes. And what we'd say in relation to this is the involvement of the English courts in anti-suit injunctions, enforcing arbitration, etc., is much more involved or steps on the toes, we'd say, much more in relation to arbitration generally. What your lordships are being asked to decide is simply, yes, they brought the arbitration, but they shouldn't have done so because they had a UK worker and it was a detriment. So we say it's much less obtrusive than what the English courts already do. So when we're looking at comity, we make that general point. At paragraph 66, there is a general test set out by the court. Summarising this part of the case, the core immunity relates to the giving of evidence, and its rationale is to ensure that persons who may be witnesses in other cases in the future will not be deterred from giving evidence by fear of being sued for what they say in court. The core immunity also provides a statement of the case other documents placed before the court. That the immunity is extended only to that which is necessary in order to prevent the core immunity from being outflanked. Whether something is necessary is to decide by reference to what is practically necessary. Where the gist of the cause of action is not the alleged false statement itself, but is based on things that would not form part of the evidence in a judicial inquiry, there is no necessity to extend the immunity. In such cases, the principle that a wrong should not be without a remedy prevails. We say that this does not relate to the giving of evidence. Who would be deterred in this case? Well, companies with UK workers who they wish to bring arbitration about may be advised to consider UK law before doing so. We suggest that this isn't a case where we are considering pleadings, so written pleadings before the court, where we're considering what a witness has said in pleadings, because one might see how that would outflank the immunity if a witness could not be referred to their evidence given in paper documents, because they might be worried about giving that evidence, but that's not what this case is.
You say your claim in detriment isn't based on what anybody said or did in the arbitration.
Yes.
Because it hadn't happened.
Because it hadn't happened.
Yeah, fine.
Yes.
The point was Williams's recording was made in paragraph 67. Yeah.
Yes.
So the fact that you've got your quasi-judicial proceedings a fortiori can't retrospectively immunise an antecedent act if it's not within the immunity to start with. It begs the question.
My lady, yes. Paragraph 41 of the skeleton argument, we make submissions in relation to what can be drawn from the case of Singh. The resident supports to extend the reach of the immunity or the core immunity, that it should not be generalised, that when looking at the statement about anything said or done, we must take account of what's said in Singh. And what's said by Lord Hoffman in Taylor and the Serious Fraud Office, that judicial proceedings immunity is very much to encourage freedom of expression. It's limited actions to which the alleged statements constitute the cause of action. And the quote from Lord Justice Waller in Serger Overseas Limited: the action is not brought simply in respect of evidence given or supplied, but is brought in relation to some broader objective, during the currency of which it may well be that evidence was given, witness immunity should not apply. We say this mitigates any attempt to extend the judicial proceedings, including to antecedent actions. In this case, it may be relevant, it may not be relevant, but my lord, you would understand in relation to an arbitration, when a request for arbitration is made, it goes to administrative position, an arbitrator is agreed, of course. So at the point where the request is made and arbitration is brought, there is no panel at that point. There is no judge at that point. So it couldn't be said that there was evidence before a judge or submissions to the judge, because there is a request, there's a consideration of jurisdiction, and then there is an appointment of an arbitrator. So we say in this particular instance, it's far before any point where the core immunity would start to operate. I know I'm almost out of time on our schedule. I've got a little bit of time. The last case I would take you to, my lord, is Daniel's Chief Constable of South Wales, with a number of causes of actions in relation to police misfeasance in a murder investigation and prosecution. The Employment Tribunal judge's findings in that case are set out at page 402. Paragraph 16, on behalf of the Chief Constable, it had been contended that the prosecutor is immune from suit in respect to the initiation, continuation, and conduct of criminal proceedings. However, counsel for Mr. Daniels has contended that such immunity is confined to what is said and done in court, and thus did not extend to the drafting of pleadings in court or the giving of advice in relation to court proceedings, and it was substantially confined to immunity on part of witnesses or those who speak in court. And it has the tribunal judge ruling at paragraph 17. It says the defendant is right to contend for immunity from suit for a prosecutor in respect of his initiation, continuation, and conduct of criminal proceedings, and that on authority is not limited to what is said or done by witnesses, as counsel for Mr. Daniels contends. At paragraph 19, in his judgment, the allegation in relation to number 4 allegation in relation to number 4 was about the continuation of a prosecution, even though it was clear that it could not have a fair trial. Was an allegation of activity intimately associated with the judicial phase of the criminal process as distinct from the administrative or investigative role, the formal attracting immunity and the latter not. In his view, the particulars were all allegations of and in support of the contention the Chief Constable continued the prosecution, and each of these matters fell within the core immunity. Paragraph 24. Undertook, continued, or maintained a prosecution. This is the trial judge said that they fell within the core immunity. Paragraph 36. The court stated a number of the speeches in Dark has emphasised immunity is essentially a witness immunity.
Paragraph 42, which is what the court actually decided, which was that the judge took too broad a view of the absolute immunity.
My lady, yes, I was going to come to that, but I think that's probably the most relevant part of it. I consider it took too broad a view of the absolute immunity. He proceeded on the basis that there exists a general immunity from suit for a prosecutor in respect of his initiation, continuation, and conduct of criminal proceedings, and that the immunity is not limited to what is said or done by witnesses. I consider the immunity applies essentially to statements made by witnesses in the course of giving evidence. It's certainly limited, but necessary extensions of that principle. The fact that an activity may be intimately associated with the judicial phase of the criminal process, as distinct from the administrative or investigative function, does not in itself necessarily give rise to immunity. Neither decisions in previous authorities nor the identified objectives of the immunity justify a rule of the breadth which he identified. Accordingly, his application of that overall principles of the draft pleadings was erroneous.
a reiteration of the Lord Morris's approach at 44.
Yes, my lady.
Is there an endorsement of what Lord Justice Lewison said in Sing, 45. The duty of the cause of action is not the allegedly false statement itself, but is based on things that would not form part of the evidence in judicial inquiry. There is no necessity to extend the immunity.
My lady, yes.
Passage for you, isn't it?
And then he states it at paragraph 46. The claim for misfeasance in public office in the present case is not founded on the content or any express or implied statements associated with services, schedule, or unused material. The substance of the claim relates to the way in which the disclosure itself is performed. We submit that once again the courts are given guidance as to what will fall within the core immunity. And it's been suggested that the immunity simply doesn't apply to the type of cause of action. But we suggest in this case, if it was simply the causes of action in this case, which meant that the immunity didn't attract to the initiation, it would have been said so. You know, the in-depth discussion we had wouldn't have been needed.
Yes.
My learned friend, there's one more authority. My learned friend relies on he and the Commissioner of Police from Metropolis. We say that case is really considering the decision in Lake about about being able to challenge the decision of the disciplinary board to the Employment Tribunal, but the contents of the decision of the disciplinary board not being attackable. We say it's not particularly relevant to this case, where we're looking at initiation. We're not going after anything which was done or said within the arbitration. Further, we say in relation to XGY, Sussex Police and XGY, that was considering the immunity of an advocate speaking in court, who inadvertently released the address of a complainant in a criminal matter. We say that's what that case is focused on.
Sorry, just going back to P and the Commissioner of Police for the Metropolis, which is at tab 20, didn't that case go to the Supreme Court? Or am I mistaken about that?
Looking at my learned friend would know more than me.
My lady, it did. It went to the Supreme Court on the EU law grounds only, and so he wasn't disturbed on Article 6 or the other matters.
I can address you further on P and the Commissioner of Police from Metropolis, but in essence our submission is that it looks at whether Lake has displaced Heath. And when it's looking at the displacement of Heath, it's looking at whether Lake allowed attacks on what happened within a disciplinary board. And we say that's not what we seek to argue from Lake. So it's limited to that point. Heath would remain good law in relation to not being able to impugn the conduct of an actual board during the board, if that was the nub of the claim or the aim of the claim. At paragraph 62 of the skeleton argument, we address some of what your lordship, your ladyships have been looking at in relation to parliamentary intention. There's a section on rationale behind the immunity, paragraphs 51 to 61. I won't take you to it, but if there's any question in relation to rationale, I can return to it. We'd say that the Employment Rights Act, section 47B, quite clearly talks about any detriment. The provision in 47J preventing the activation of a clause if it may be in breach we say shows the intention of Parliament not to allow the use of overseas litigation against a whistleblower when they wouldn't be able to do the same within this jurisdiction.
And the employment judge gave that some weight, see paragraph 73.
He did.
In his judgment.
And we would say he was right to do so, that it must, when one looks from the objective point of view of Parliament's intention in relation to it, why would they agree or draft
What the employment judge said at the end of that paragraph was it would be very difficult to distinguish between an argument that Mr. Rogerson could not pursue his claim because of the confidentiality agreement, which would be impermissible under section 43J, and an argument that he could not pursue his claim because the respondent would commence proceedings to enforce that confidentiality agreement. It's the basis of the claims immunity.
Yes. Respectfully, you have our point in relation to parliamentary intention, that Parliament cannot have intended to provide strong protection for whistleblowers, but allow for overseas litigation to be brought against them. There's no public policy in relation to that. In relation to the extension generally of judicial proceedings immunity overseas, there's two cases my learned friend relies upon. One is Hasselblad, which was the European Commissioner, or the European Commission, which received a complaint. In that case, it was held that the Commission was not a judicial body, and my learned friend relies on that to say, well, it does seek to show that judicial proceedings does apply to overseas tribunals. But there is a more recent authority in relation to that, which doubts that that's what Hasselblad says. This is the case. Commercial Bank of Dubai, PSC and El Sari and others, which is page 689 of your bundles, which is the High Court case.
Yes, that's come separately. I'm afraid my bundle doesn't extend that far.
769 pages of the authority bundle.
Hold on.
So tab 30.
Sorry. There's a second bundle. I haven't remembered that.
Mr. Justice Foxton's.
He doubted whether Hasselblad was authority for that rule. He came down on the side of that it does apply overseas when it's supported by local law.
What paragraph would you like to look at, please?
The modified rule he speaks about at paragraph 124. He states at 106, paragraph 116, the position in regard to arbitration is interesting, not as clear as it might be. I've found no English authority considering whether JPI applies to evidence given by witnesses in domestic or non-domestic arbitration proceedings. He refers to United States case of Rowland and Henneman, where I understand judicial immunity was applied to a witness before United States domestic arbitration. But he says he found no authorities, English authorities, about whether it applies, and this is even to witnesses, because he's focusing here on witnesses in domestic or non-domestic arbitration proceedings. He does say that he thinks it does, not in the way that the learned Employment Appeals Tribunal judge said it does, but he said a modified rule where you look to the law of the other jurisdiction. he says that it's paragraph 127. I can see a principled case for the modified rule. I've taken a different view from Justice Heather Williams, and the conclusion to be drawn from Hasselblad. And I've concluded that the position of arbitration, which was a specific context he was faced with, can be justified on a different basis. Respectfully, we say the point about witness immunity being available in overseas arbitrations is not the most relevant point in relation to the incident case.
I'm so sorry to interrupt, Mr. Perry. Is the judgment of Mrs. Justice Heather Williams to which he's referring to one in this case?
Yes.
Okay, I just wanted to be clear.
Um,
Thank you.
she decided that Hasselblad showed that there was extension of judicial proceedings immunity to foreign cases, in short. And he said he disagreed for the basis of it. That came down on the side of a modified rule. There's no, as far as we know, there's no higher authority in relation to that. In any event, what we would say is that there's doubt, although the court may come down on one side or the other about witnesses in overseas arbitrations or domestic arbitrations having witness immunity, but there's a much stronger argument for that than there is in relation to there being immunity for the bringing of them. We say because of the general tenor of what English courts have recognised that witnesses is really one of the main aims of the immunity.
I think you gave permission to appeal on whether it's a bright line rule or a modified rule. I don't know whether the appeal has actually gone ahead.
I don't know. I don't know if my learner friends know.
Not to our knowledge.
It's an interesting point, but I'm not sure it's at the centre of this appeal.
No, my lady. We simply say this in brief. My learner friends refer to Singapore cases which say the judicial proceedings immunity apply in Singapore. We say that's not surprising given its common law jurisdiction, but there's no authority saying that the initiation in Singapore would be caught by this by the positions. In relation to ground 3, the learned judge was wrong to find the comity requires or supports the extension of judicial proceedings immunity. We speak about this paragraph 70 of the skeleton argument. We say the comity is not in effect a one-way street. That what comity requires is with respect to and support of arbitration, but not to the extent that support would block UK workers from exercising statutory rights, where it appears that Parliament is seeking to prevent that kind of action. And the Learned Appeal Tribunal judge stated, this is set out in paragraph 72 of the skeleton argument, there is a particularly strong public interest in ensuring harmony between English law and related foreign law in the context of foreign seas arbitrations in order to support the integrity and proper functioning of the arbitral proceeding. We're not respectfully requesting that those proceedings were to be stopped. They hadn't been decided at the time of the tribunal claim, and she refers to the respondent's reference to a strong international public policy in support of arbitration reflected in the New York Convention. We say that this case would not go against that strong international public policy in support of arbitration, and we say that there is a counterbalance to that, that those with UK lawyers, those with UK workers should not be able to bring actions against them outside the United Kingdom. One is,
Sorry.
apologies, my lady.
No, I'm sorry to interrupt again. This idea about strong international policy, has the New York Convention been brought into domestic law in any way?
Yes.
Oh, it's in the Arbitration Act, okay. What is that? Because I don't know anything about this. What does the Arbitration Act say about?
I don't have the Arbitration Act in my mind.
I mean, my basic question is it relevant in any way to the issue here?
I think I wouldn't argue against my learned friend saying that English courts recognise arbitration and support them. I wouldn't say that. I would just say that comity, it would be a stretch of comity to say that international organisations or companies can act outside of English employment law protection, and that by not doing so, by recognising this case, we would be infringing upon the arbitration. The arbitration is done, finished. We don't challenge what was said in it. So we say.
It seems to me that if the arbitration had gone the other way,
yes,
that is to say, there was a breach of confidence,
yes,
then and if the English Employment Tribunal said that this was protected disclosure, then as a matter of public policy, the Singapore Award would be recognised or enforced here. And that is applying the New York Convention, which says that you don't have to enforce an award if it's contrary to domestic public policy.
my lord, I'd never considered that because of the way the arbitration went. But your lordship has it's a good point. That the English courts, as I've said before, take much more intrusive steps than merely saying we shouldn't have brought it. In short,
We are in general very supportive of arbitration, including New York Convention awards, which are by definition seated elsewhere. But there are nevertheless within the convention and in our legislation grounds on which you don't have to recognise or enforce them.
yes,
Quite limited, but public policy as well.
I can see how if we had lost and the arbitrator found for the respondent, we may have had a potential claim not to enforce it. And respectfully, of course, that goes to the point about comity being a dual process, because arbitration needs us. It needs a domestic courts to operate, to enforce, and with that, we say it has some responsibility, or companies have some responsibilities, even when they have an arbitration law clause, to recognise domestic provisions, especially in the area of whistleblowers and workers. Would be our point in relation to that.
I think there's some authority on that in relation to arbitrations involving consumers. That may not be in the case of employees or workers, but it's a broadly similar rationale because the law recognises that is an unbalanced relationship.
Yes, yes, my lord. In relation to the final point, it's and it may be that this is not a point which is the most germane in relation to the arguments. I'm just checking the time. I've got a few moments, but we would say that this case, if immunity was applied, would be a breach of Article 6. We say there's a recognised right of a whistleblower not to be subject to detriments, which raises Article 6. We say judicial proceedings immunity is not a substantive bar but a procedural bar. In the case of Heath, respectfully couldn't say one way or the other. And the case of Heath is interesting in relation to the Human Rights Act point, because it looks at whether the Article 8 rights of the witness being asked to demonstrate how she was sexually assaulted were breached or could be argued, and does a balance with the police officer's right to a fair hearing to have his case properly put to the witness. And then they adopt that in relation to Article 6, only briefly, saying that there's potential balancing because there were two rights being balanced. Respectfully, in relation to that, is that we say that there is no balance in this case. The Article 6 access to a tribunal of Mr. Rogerson to the Employment Tribunal is not balanced against some competing right of the respondent. There is no right to bring arbitration without consequences. We're not, if it was a case where we're seeking to stop access to arbitration, there may be a counterbalance, whether that would succeed or not.
You're saying that there's no initiation of any proceedings by you to injunct them from bringing arbitral proceedings.
Yes. So there's no
They
counterbalance.
just did it at their own risk.
Yes. Those who bring arbitration against UK workers face a risk, and they took it. And we'd say there's no counterbalance. So when this court, if it considers proportionality in relation to access to the tribunal, which we say is open to this court, there's no counterbalance.
I suppose it might be said against you that just as the witness immunity is justified on the basis that it has a chilling effect on somebody willing to come forward and give evidence that the prospect that they might be sued, likewise it might have a chilling effect on a totally upright and blameless employer from pursuing his right to enforce a confidentiality clause against, let's say, a malicious employee, not this case. If he were to face that same employee, then taking him to an employment tribunal and saying it was all as a result of a protected disclosure.
My lady, it could be said that there's always a risk when there's a right context of people misusing them. Whether that's right not to have the fear of a case being brought about you is to the level of a competing Human Rights Act, a right to be balanced against the right of access to the tribunal.
Well, it's his access of right to, it's his access to, the employer's access to a tribunal. And the argument would be, well, he's inhibited from pursuing his rights to go to the tribunal which his employee has agreed he should go to in case of breach of confidence, by the fear that if he does so, he will be subjected to process in the ET.
Yes.
That's the argument.
My lady, yes, and if I may address it like this, there may be a level of inhibition, but that would be balanced against the total prevention of Mr. Rogerson bringing his claim.
Yes.
So the point is,
you might say that if Mr. Rogerson could, it shouldn't be struck out at the beginning. In other words, there would still be satisfaction because all we're talking about is a threshold.
yes,
And if the detriment were allowed to proceed with the fact that it wasn't protected disclosure, then the employer would have his remedy anyway.
yes, my lady.
I wonder whether Article 6 really adds anything to your case. If you win on what you've said so far, you don't need it, but if you lose on what you've said so far, and there is an immunity which extends to the initiation of proceedings, including proceedings abroad, because that is important to the administration of justice generally in the public interest, then is Article 6 going to get you home?
It would depend on if the decision was that it was a core automatic immunity, or if it was a discretionary immunity where the interests of justice need to be considered. If it was, your Lordship says, an automatic immunity, it could be challenged on the basis whether that's necessary to have as an automatic immunity initiation, because for witness immunity there's a clear rationale, we would say, for initiation immunity. If the court was to find that, we'd say there is no clear rationale. So we would say that even in those circumstances.
Well, this is, it assumes there is a clear rationale, doesn't it? Because if there isn't a clear rationale, then there won't be an immunity under domestic law anyway.
Yes, I can see your Lordship's thoughts on that.
I mean, it's always nice to have
Yes.
a convention argument as well, I suppose, particularly when it comes last. But I'm just wondering whether, if you lose on all else, that really is going to make a difference.
My Lord,
You don't have to.
I say no more in relation to that.
I guess the other point is we've got to bear in mind that this was a preliminary issue, so no facts have been found. And my understanding is if the court's considering a preliminary issue like strikeout, you assume the facts in favour of the claimant. You say, okay, well, let's assume he's made a protected disclosure. What follows?
Yes. The order requested from your Lordship, your Ladyships, is set out at page 7 of the court bundle, and we respectfully request that the appeal be allowed, nor be granted by the court. The judicial proceedings immunity doesn't apply to the claimed detriment of the initiation of arbitration against the appellant, and that this is reinstated and the matter is sent back to the Employment Tribunal for further order. Thank you, my lord. Thank you, my ladies.
Very good, thank you very much. Mr. Kemp.
My ladies and my lords, I appear for the respondent with Mr. Mather, and this will be a submission made in two halves. I will cover the terrain covered by grounds 1 and ground 2 of the appeal, and Mr. Mather will cover grounds 3 and ground 4 of the appeal. Can I just start by making two preliminary points? First, the facts in this case are hotly contested. There have been no findings of fact yet made by the tribunal. The relevant finding of fact for current purposes is that the arbitral tribunal is a quasi-judicial body. That finding hasn't been challenged on appeal. The second preliminary point is one raised by my Lord Justice Mayles about the arbitral award and request for arbitration. Those documents, both those documents, are confidential to the arbitration, and our principled case is that detriment 3 amounts to a collateral attack, and that the protection of judicial proceedings immunity is designed to prevent scrutiny of those documents. And so, for those reasons, we do not place the documents before the court. In addition, the court will want to note there was an application made by the claimant to adduce or admit confidential documents from the arbitration before the Employment Tribunal. But they didn't get round to dealing with it because they ran out of time and the matter was postponed to a later date. So there is currently a live application before the ET to rely upon those documents. And so I propose to say no more about that. My Lady Justice Andrews was correct that the central question in this case is whether the claimant's claim in respect of detriment 3 falls within the scope of the core immunity. And before I take you to our analysis of the pleaded claim and the issues as to which there is a disagreement between the parties, the logically prior question is what is the ambit of the core immunity and whether it applies here to a party and whether it applies to the initiation of the proceedings. Just before I outline it in a bit more further detail the structure of my submissions, I want to deal with one matter head on, if I may, which is that if you're with us that the detriment 3 falls within the scope of the immunity, that's the end of the matter. The claim falls to be struck out. All of the other issues are immaterial in our submission. It's important, I'll make some further submissions on it in due course, but XGY is the latest case on immunity from the Lady Chief Justice, and she deals with the issue of statutory interpretation and the intersection between that and the immunity. And she says this, that the question is whether there's anything expressly or by necessary implication that dilutes or modifies the common law immunity if it applies. That's the approach to take. And she there will go into the case in due course, I hope, which applied to the Human Rights Act. We say that the same analysis applies a fortiori to the Employment Rights Act 1996. Is there anything expressly or by necessary implication that dilutes or modifies the common law immunity? Answer, we say no.
Well, that presupposes the immunity applies.
Yes, of course,
If you don't get past that stage, then you don't get into XGY.
Of course, we accept that.
Is XGY one that we've got?
It is. It's right at the back of the second volume of authorities in, I think it's tab 38. But we will, 39, I will come on to that, my lords, in due course, if I may. But it does deal with that important question, that if the core immunity applies, what are the consequences? It deals with that consequence on statutory interpretation, but it also deals with another point.
I don't think I've got it, so if you would be kind enough to bring a copy for me, if we're going to get to it after the adjournment, then that...
Has my lord not got a copy in the authorities, my lord?
Back in the second authority.
It may not have been inserted into
I think it's page 102. It's an 8th of October.
It's been inserted at the front of the second one.
Yeah.
All right.
But I don't want to steal the.
Tab 28. Anyway,
I don't want to steal the thunder of my own submissions because I will take you through the relevant paragraphs in due course.
That's fine.
But the other point to take from XGY is that whether or not core immunity applies is a binary issue either it applies or it doesn't. There is no justificationalism, so there is no weighing up of policy factors at the stage of deciding whether or not the core immunity applies. One only does that if one is talking about an extension of the core immunity. Then one does weigh up the policy considerations and Article 6. We say that this is a case that falls within the ambit of the core immunity, and so there's no need for the court to weigh up those policy factors. Can I address you?
It's a case that says that the initiation of proceedings is subject to the core immunity.
I'm going to take you to a series of cases to support our submission that the core immunity does apply to the initiation of the proceedings, my lady. Yes, there's a whole section of my submissions on that point. But just before I go into that, another provision is Section 43J of the Employment Rights Act that's been brought up. And if I may just briefly address that, this is the provision that renders void any contractual provision that precludes a worker from making a protected disclosure. Can we say this, that the agreement to arbitrate is a broader provision than that. It is not an agreement, it's an agreement to arbitration. It does not per se purport to exclude a worker from making a protected disclosure. The second point is there's no basis for any submission that Section 43J was intended by Parliament to apply to the whole world. That the question of jurisdiction of the arbitration, where the clause is being exercised, is a matter squarely for the Arbitral Tribunal in Singapore, applying its own rules of jurisdiction and its own applicable law provisions.
No, it's a substantive provision. It's nothing to do with jurisdiction.
No, but my lady, the point is that Section 43J is a red herring in this case because it doesn't prevent the foreign court, obviously, from having jurisdiction to hear.
It doesn't deprive a court of jurisdiction, and it doesn't, on the face of it, because it's broader, as you say, it's not in terms directed to the initiation of arbitral proceedings. But if the arbitral proceedings have the effect because the purpose of the arbitral proceedings is to stop somebody making a protected disclosure, then there could be an argument, couldn't there, that it falls foul of 43J.
Well, we submit that is not the case because one is here dealing with the common law immunity, which we will say has not been diluted or disapplied in any way in terms or by necessary implication by Parliament. And there's nothing in this case that demonstrates that Section 43J has not been respected. As I indicated earlier, the claimant was accepted to be a worker for the purposes of the tribunal proceedings. He was able to bring his Employment Tribunal claim for detriment for making protected disclosures. Those claims are allowed to proceed subject to the issue of time limits and whether or not judicial proceedings immunity applies. The only potential relevance of Section 43J might be a public interest or policy point, but as I've submitted, XGY is clear that only becomes relevant if you accept Mr. Pollack's case that this is an extension of the core immunity. It's not a relevant factor when one is considering whether or not the application of the core immunity applies to the substance of the detriment.
But what about the confidentiality clause? Because the confidentiality clause is on its face to apply to 3J, if to the extent that it's seeking to prevent the making of protected disclosure.
A confidentiality clause may fall within the ambit of Section 43J, but there is nothing that Section 43J is being respected in this case. The claimant has been able to bring a claim for protected disclosure detriment in the Employment Tribunal, subject to applicable time limits and the application of the common.
But he's being subject to arbitral proceedings in Singapore for breach of the confidentiality clause, as I understand it.
Well, we submit that this the Section 43J and its relevance, it only becomes relevant on the issue of public interest and public policy and balancing. It doesn't become relevant as a complete substitute to the application of the core immunity at common law. there are no, what is required are express words or necessary implication to disapply the core immunity, and that test is not satisfied by section 43J or the words any detriment in section 43B1.
You said that the prior question is what is the ambit of the core immunity? Isn't the first question whether the initiation of proceedings in Singapore is a detriment? And do you say that it's not a detriment?
My lord, we say that the logical question is what type of immunity is engaged here? Here, the type of immunity is party immunity. How does it apply? It applies to the initiation of the proceedings.
Well, surely that comes after you've addressed the question whether the initiation of proceedings is a detriment. It may be that it's a detriment from which you are, in respect of which you have immunity, but surely the first question is it a detriment?
Well, my lord, can I indicate that both the issues of detriment and causation are disputed in this case? So there's no common ground that it is a detriment. So there is a question for the tribunal as to whether or not detriment is established.
But you have to assume for these purposes that it is a detriment, otherwise we're not, because you've got to assume for these purposes that you take the claimant's case at its highest.
Yes, we don't disagree with that proposition, but we say that the initiation of the proceedings is sending the request for arbitration, which is caught by the core immunity.
Leaving aside immunity, what is the argument that it is not a detriment to face arbitration proceedings in Singapore as a result of the disclosure?
Well, my lord, we agree with Lady Justice Andrews' conception that on a strikeout, one has to take the case at its highest. And so the issue is taking the claimant's case at its highest, that the detriment alleged is the commencement of the arbitration in Singapore. Does that is that caught within the ambit of the core immunity?
Well, I know you say that, but I know we have to take it at its highest. But at the moment, I cannot understand an argument that the initiation of proceedings in Singapore is not a detriment. And if there is an argument that it is not, I would like to know what it is.
Well, my lord, detriment is a broad concept in English whistleblowing law. We accept that. We disagree with Mr. Pollack that the ambit of his case on detriment is simply that it was confined to the commencement of the proceedings. So our case is that, properly analysed, his pleaded case was broader than that. The following sentences after that first sentence of 16G are particulars of detriments. And so we say that his case has to be looked at in the round. What was the gist of the case? The gist of the case wasn't just commencement of the arbitration. It was more than that. That's the case that he was running before the Employment Tribunal. That's the case that he was running before the Employment Appeals Tribunal.
The Employment Tribunal just treated it in quite a short way.
Well, they did, but with respect...
I have to tell you, Mr. Kelly, that in what you said, I have not heard an answer to my question. You don't have to answer it, but I haven't heard an answer.
Well, we're not making any concessions at this stage as to whether or not it's a detriment, but my lord, we agree that the test for detriment is a relatively low threshold, but we also agree that on a strikeout application, one takes the claimant's case at its highest, but we say that it nonetheless falls within the ambit of the core immunity for reasons that I will go on to submit.
So is the position that at present you can't think of an answer to my lord's question, or you don't want to answer it?
Well, I don't want to say anything that might prejudice my client's case in due course at tribunal, bearing in mind that our pleaded case is to deny that there was a detriment.
Well, exactly, and I just wanted to know what the basis for your pleaded case is.
What
is the factual basis, or indeed the legal argument that it can't amount to a detriment?
Well, he went on to win the arbitration.
Well, that can't be right.
That happened afterwards.
The question is, when it was done, when the proceedings were initiated, was that a detriment or not?
Well, what we say on that is that we agree that there was an act which was commencing the arbitration, but our position is that detriment does need to be considered in the round, in the context, in light of evidence from Mr. Rogerson, for example, as to the effect of that act. But our principal position at this stage.
Well, his evidence wasn't really welcome.
Well, there hasn't actually been evidence given yet because the Employment Tribunal was simply considering a strikeout rather than hearing any evidence as to the detrimental effects.
Complaining about being subjected to arbitral proceedings in a foreign jurisdiction, which, on the face of it, are going to cost him money and time to defend.
And
I would
anxiety.
have thought that there was a pretty strong argument for saying that that's a detriment. Now, it may be protected, it may be subject to core immunity, but it's still something that it makes him less well off than he otherwise would be.
My lady, we don't strongly disagree with that interpretation. All I would say is the tribunal hasn't made any findings of fact yet, and the question of detriment will be one for the tribunal to consider in due course in light of evidence as to its effect. But the key point, because we're dealing with a strikeout, is that you take the claimant's case at its highest and assume that detriment is capable of being proven, and then we say that taking his case at its highest, it falls within the ambit of core immunity. And that's the section of my submissions that I want to develop, hopefully before lunch.
All right, we'll let you get on and do that.
So is the ambit of the core immunity only a witness immunity, as my learned friend appears to suggest, or does it cover the initiation of the proceedings? And our central submission is as follows. This is a parties immunity case. Parties enjoy core immunity, we say, in respect of the initiation of proceedings. The initiation of proceedings takes place by the submission of the initiating documents that constitute the proceedings. The core immunity covers the initiation of proceedings, which encompasses the contents of the initiating documents and the submission of the initiating documents. And what I propose to do is take you to 4 authorities which we say supports
You
these
say it
propositions.
covers the content of the initiating document, but you're not prepared to show us the initiating document.
My lord, in principle, it does cover the content of the initiating documents.
How can we rule on it if we haven't seen it?
Well, this is a question of principle, my lord. It doesn't require descending into the facts of what the content of the document contains. And in fact, if I may say, that rather defeats the purpose of the immunity. But let me take.
Don't confuse, please, immunity with confidentiality. They're two very separate things.
My lady, of course. But let me take note of that position, and I will take some instructions over lunch on that.
I read that it's confidential, the parties can agree to go to see it. Mr. Rogerson, for his part, through counsel, is prepared to do so, so perhaps you might take your client's instructions.
My lord, of course, I haven't yet had the luxury of doing that, but you have our position in principle on the documents.
Yes.
Can I go to Lincoln and Daniels first, which is tab 7, please, of the authorities? And this was an action for defamation brought by a Queen's Counsel in respect of a letter sent to the Secretary of the Bar Council alleging professional misconduct. One of the issues for the court was whether absolute privilege extended to the letter of complaint to the Bar Council. The court held it didn't. And I want to take you to a couple of passages in Lord Justice Devlin's judgment. So if we start with page 257 of the authority, and it's page 88 of the authorities bundle.
Sorry, which tab is that, please?
We're in tab 7, my lady, and we are on page 257, Lincoln Daniels, page 88 of the authorities bundle. And we have there Lord Justice Devlin's classic 3 categories of judicial proceedings immunity. And you see there where it says the second covers everything that is done from the inception.
Where are you reading from?
Page 257, the bottom of the page, my lady,
Thank you.
where it starts, the first category covers. It's a section that's sidebarred there on that page. It says the second covers everything that is done from the inception of the proceedings onwards and extends to all pleadings and other documents brought into existence for the purpose of the proceedings, and starting with the writ or other document which institutes the proceedings. And then Lord Justice Devlin goes on to identify the third category as being the most difficult of the three to define, based on the authority of Watson and McEwen, which is that the privilege attaching to evidence which a witness gave quorum judice extended to the pre-recognition or proof of that evidence taken by a solicitor. So the third category is when it's necessary to extend witness immunity to cover certain documents created outside of the proceedings. So when the later authorities speak of an extension, it is in the context of this third category. We submit that we're not concerned with this third category here. We are not seeking to extend the immunity to matters outside of the proceedings. Our cases, there's no extension to speak of here. And one has to ask the question, what is the proper ambit of the second category of Lord Justice Devlin's categories? And we get the answer to that on page 259 of Lincoln and Daniels, page 90 of the authorities, where he says at the top of the page, where it's sidebarred, on such a point, form is of the first importance. It is by form rather than by the substance of the complaint that a writ is to be distinguished from a letter before action. So a writ initiates proceedings that a mere letter before action does not. We say that this is important here. We say that in this case, in form, proceedings are initiated by submitting the request for arbitration to the Secretariat. We know that because that's what the relevant rules of the arbitration provide, Article 4.1 and 4.2 of the ICC rules. Just for your reference, that's in authorities on page 13. And the proceedings are commenced when the request for arbitration is received by the Secretariat of the arbitration. So we submit that we are, in this case, within the boundaries of the second category identified by Lincoln and Daniels. And we are not, in my submission, within the ambit of the third category, is our submission. And I want to develop that submission by taking you now...
Mr. Kemp, answer me this question, please. Lincoln and Daniels is all about absolute privilege against defamation proceedings. And what it says is that if you fall within category 2, then you can't sue somebody for defamation in relation to anything that is said or done from the inception of the proceedings onwards. How does that help us as to whether or not the inception of proceedings, something other than defamation, is covered by judicial immunity?
Well, we say it helps us because it provides guidance on what the ambit of second category is. We say that in this case we are within the ambit of that second category. But I do need to take you to some further cases, my lady, to develop this submission further as to what that entails and what that covers, if I can put it that way. Can I now turn to Darker, which is in tab 13 of the authorities bundle. And my ladies, my lords, as will be clear, the issue before the House of Lords in that case was whether JPI should be extended to statements made in the investigative process that didn't form part of their participation in the judicial process as witnesses. So, in other words, this was a case within the third category of JPI identified by Lord Justice Devlin. But I do want to go to a number of seminal passages in this in the House of Lords judgment in 3 of their lordships' opinions, which provides necessary context for the submission. So if we start with Lord Hope on page 445 of the authorities authority, page 254 of the authorities bundle. and his statement of the immunity is there at the beginning, at the end of that page, over the page at 446 through to B. And a couple of points to note from that statement. Firstly, the immunity extends to everything done. That's a concept that I'm going to come on to in a moment. That's been considered by another law lord in this case.
I'm so sorry, Mr. Kett, it's my fault. Which page are we on again?
So we're on page 446, page 255, and we're at A and B. And there are 2 points to take from Lord Hope's statement that are material in this case. First, the immunity extends to anything done in the ordinary course of the proceedings. And second, that the immunity, the same immunity that the witness has, is given to the parties, which forms the basis of our submission that the type of immunity here is parties' immunity.
But you can't divorce that particular statement from the next sentence, which says they are all immune from any action that may be brought against them on the ground that things said or done by them in the ordinary course of the proceedings were said or done falsely and maliciously and without reasonable and probable cause.
My lady, yes, that's the effect of the immunity there by Lord Hope, but the principle as to the ambit, we say that the statement there by Lord Hope, the ambit does cover anything done and the immunity is given to the parties. These are the points that we take from Lord Hope's statement of the immunity there, but obviously we bear in mind the proper context of this case, which is that they are there considering witness immunity, not parties immunity. And this is a point that Lord Clyde makes in his opinion, if I can just come to that now, which is at page 456 of the authority, or page 265 of the authorities bundle. And firstly at D, Lord Clyde says that the immunity has in the past been recognised ... in respect...
The immunity from initiating proceedings, if there is one, would be for the benefit of the person who initiated the proceedings. That's Mr. Rogerson, but he's not claiming any immunity.
No, it would be the immunity would be for the parties.
No, sorry, I withdraw that.
It was the respondent as the party who brought the proceedings. But the point I was making earlier about the proper context, and this is the health warning that comes when looking at the cases in this area of law and what they decided, comes at E in Lord Clyde's opinion, which he says this: it may be that distinct considerations may apply to some or all of the other groups. It is proper to restrict the present discussion to the immunity of witnesses. Yes. And we say that one must carefully consider the immunity that's in issue in each case to understand the proper context of judicial statements as to the ambit of the core immunity. And we say this: what distinct considerations may apply with parties' immunity, distinct as opposed to witness immunity? It is the party who initiates the proceedings. One of the public policy grounds for witness immunity is described as witness inhibition, the freedom of expression to make statements without fear of being said on something they said. It may be more apt, in a case involving parties' immunity, to describe this public policy ground as party inhibition, that is, the freedom of the party to initiate the proceedings and to express the complaint that is the subject of the proceedings without fear of being sued on it. So it is an adaptation of the witness inhibition public policy grounds to the immunity that's in issue here, the party immunity that we say is of relevance. We then get Lord Hutton, whose opinion can be found at 463 of the decision, which is 272 of the authorities bundle.
If it's to do with inhibition, public policy, indeed the legislation, is that employers should be inhibited from taking steps which amount to a detriment. Isn't it?
My Lord, that's a separate matter. Here, when one is looking at the public policy rationales for the core immunity, one of them is witness inhibition, the other one is multiplicity of actions. And here we are saying that a justification for core immunity when it comes to the party is to describe witness inhibition as a party inhibition. It's the same point, essentially, that we're making. It's that the party needs to have the feel free to participate in the proceedings, that is by initiating the proceedings and express the complaint that's the subject of the proceedings without fear of being sued on that later on in further proceedings.
Is there any authority which supports this?
There isn't an authority which an authority which deals with the repackaging, as it were, of the witness inhibition public policy as party inhibition.
No.
But this is the submission that I make. It is not to reconstruct the public policy that is in play. The same ground is in play. It's just it must be applied to in the context of a party in order to give meaning to parties' immunity.
Parties' immunity is something that you invented.
No, it is not. It is an immunity that has been recognised by the.
That was the point of my question. Which authority recognises what we call party immunity?
Well, we submit that the passages in DACA confirm that the immunity of witnesses has been extended to parties. We do also rely on Lincoln and Daniels in support of that proposition.
That's a case about absolute privilege and defamation.
Well, that's the point.
Well, and we do rely on the. I think there's an earlier case, Dawkins and Lord Rokeby, which yes, if you go to tab 4, page 263. Kelly CB, where he says this is the bit that's sidebarred. The authorities, I think there's a spelling mistake there.
No action of libel or slander lies against judges, counsel, witness, or parties for words spoken or written in the ordinary course of proceedings. And Lord Devlin then says, well, that includes anything that is said or done from the initiation of proceedings onwards. See number 2 of his categories, all about libel and slander and defamation and the ability to speak freely without inhibition, subject, of course, to all the caveats that we have about malicious prosecution and the cases that we've seen this morning on that.
My lady, it's in fact Kelly CB who goes on to, over the page, having reviewed further authorities, that no action lies against parties or witnesses for anything said or done in the ordinary course of any proceedings in a court of justice. And it is, those words are considered later on in DACA. I'll come on to that in a moment. And also by the Court of Appeal in Daniels as to what they mean. But we say
it's not a statement intended to exclude any action at all. It's a statement made in the context of a defamation claim.
And he says, although falsely and maliciously and without any reasonable probable cause. So something that may be said falsely and maliciously and without any reasonable probable cause. I mean, you can't read that passage as saying, well, you can't bring a claim for malicious prosecution, because you plainly can.
Well, that passage has been the subject of judicial scrutiny in the later cases, and I do want to take you to, just before we break for lunch, this is I think my last point on DACA, a passage given by in Lord Hutton's opinion. So if we go to 464 of DACA, which is page 273 of the authorities, Lord Hutton deals with that rule that I've just taken you to in Dawkins B, and he says this, he says the reference to anything done was probably intended to cover the submission of a written statement to court. And whilst that's obiter, that in my submission is strong obiter dictum from the lead judge in the House of Lords in Darker, and we say that supports our submission that anything done is intended to cover the submission of a request for arbitration and other statements of case, not just the content of the documents themselves. And I will, after lunch, return to that point when one considers the Court of Appeal's treatment of the dicta in Daniels.
Right. I've lost it.
Thank you. I'm grateful.
Court rise in favour.